Testing, testing. Welcome to the public. There we go. Welcome to the Public Service Commission. For the record, I'm Kumar Barbe, the chair. Let's start by approving the minutes from the previous meeting, unless anybody has any additions or deletions. I'm going to move that we accept the minutes from the prior meeting. All those in favor signify by saying aye.
Aye.
Opposed, no. The ayes seem to have it. The ayes have it. Let's go to the consent item. And that's item number 1, Washington Gas Light Company. The filing is for revised tariff pages, updating POR discount rates. The motion is to accept the tariff revisions for filing with an effective date of June 29, 2026. Okay. All those in favor signify by saying aye.
Aye.
Opposed, no. The ayes seem to have it. The ayes have it. That does it with the consent agenda. Let's go to items number. It makes sense to do items number 2 and 3 together. So item number 2 and 3 are both Washington Gas Light Company. The filings are for a request for approval of Dresser D630 of a Dresser D630 gas meter, and the request for the approval of Itron Intellis 425 gas meter. The motions are to grant the company's request for approval of the Dresser D630 gas meter type and design for use in revenue billings, and the motion for item number 3 is to grant the company's request for approval of the Itron Intellis 425 gas meter type and design for the use in revenue billing applications. Let me turn now to staff.
Good morning, Mr. Chair, Commissioners. Michael Spiegelman on behalf of staff. This item concerns a request by Washington Gas Light Company filed on April 14, 2026 for approval of an Itron Intellis 425 ultrasonic gas meter and Dresser D630 rotary gas meter for gas metering application. Public Utility Article Section 7-301A requires a person to obtain commission authorization before use of gas or electric meters. Comar 20.55.0502A further requires that before any meter may be installed for use for revenue billing purposes, the type and design of the meter shall be approved by the Commission. In addition, Comar 20.55.02.02B4 requires that the gas meters comply with appropriate American National Standard NZB 109. In the present filing, Washington Gas has provided documentations that the meters have been tested and conformed to all applicable NZB 109 standards for gas meters as required by Comar. In addition, Itron Intellis 425 gas meters are already deployed in 24 states. It has also been approved by Measurement Canada per notice of approval AG-0642. The Dresser D630 gas meter has been approved by the Measurement Canada per notice of approval AG-0611 and by the New York State Public Service Commission. Furthermore, the Commission has previously approved other models of Itron and Dresser gas meters. Therefore, staff recommends that the Commission approve Washington Gas request for approval of the Itron Intellis 425 and Dresser D630 model gas meter for gas metering applications in Maryland. If approved, staff will update the list of approved devices located on the PSC website. Thank you.
Thank you. Any questions for staff? Seeing none, thank you very much. Company, do you have anything you'd like to say?
We just appreciate staff's review.
Okay. Anybody else want to comment about this? All right. Seeing nothing. Oh, well, obviously there's nothing to ask you if you. All right. Okay, we'll proceed to a vote. Commissioner McLean.
Aye.
Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Hoover. Aye. Chairman votes aye. The motions carry unanimously. Item number 4, also Washington Gas Light Company, the calendar year, pardon me, it's the calendar year 2025 annual stride report. The motion from staff is to note the company's calendar year 2025 annual stride report filing, which includes the company's 2026 surcharges with the corrected calendar year 2024 data and calendar year 2025 stride reconciliation factors. Let me turn to staff.
Good morning, Chair Barvey and members of the Commission. Staff presents Jamie Smith of the Accounting Investigation Division, Ivan Thomas of the Telecommunication, Gas and Water Division, me, Negusa Tesfaye of the Engineering Division. Strategic Infrastructure Development and Enhancement, or STRIDE, is a program authorized under Public Utilities Section 4-210 that allows the accelerated replacement of certain gas plant infrastructure in a 5-year plan with cost partially recovered using a surcharge. Each year, utilities are to make a reconciliation filing regarding actual cost and collections under the surcharge. On March 13, 2026 and on March 16, 2026, Washington Gas filed the company's initial and amended calendar year 2025 annual STRIDE report and financial reconciliation associated with the calendar year 2025 STRIDE work. The company's filing provided an update on the company progress regarding the implementation of the overall STRIDE program through December 31st, 2025. As of December 31st, 2025, the company remediated or replaced 2,099 services of the 2,169 planned. Additionally, 3.3 miles of mains were installed compared to 3.1 miles planned, and 3.6 miles of main were retired from the system against the planned 3.5 miles. Washington Gas spent approximately $52.76 million on these projects, which represent roughly 101% of the company's estimated total cost of $52.39 million. Staff has reviewed 2025 financial reconciliation and determined that the calculations are accurate, as Washington Gas STRIDE 3 January to December 2025 collections totaled $15,919,762. Washington Gas also experienced a 2025 under collection of $1,908,241, which includes a beginning balance of $2,245,043, reflecting the corrected 2024 position. Staff recalculated the total cost of $16,582,917 less interest of $999,957 equals the actual STRIDE revenue requirement for 2025 of $15,582,960. Table number 11 shows the company's STRIDE reconciliation factors for each customer class. The reconciliation factors are added to the currently effective STRIDE surcharge to determine the net STRIDE surcharge for each customer class. The net STRIDE surcharges are then compared to the applicable customer class surcharge caps. The resulting residential surcharge for the upcoming period is $2 per month, which is a statutory cap. Staff recommends that the Commission note the company's calendar year 2025 annual STRIDE report filing, which includes the company's 2026 surcharge with the corrected calendar year 2024 data and calendar year 2025 STRIDE reconciliation factors. Staff are available to answer any question you may have, and thank you.
Thank you very much. Any questions for staff? Commissioner Suchman.
Morning, Mr. Tesfaye. How are you?
I'm doing fine.
Good.
Morning, Commissioner.
I have some sort of, I guess, engineering questions within your area of expertise, but I have some legal questions too. And Ms. Herman, are you going to be responding? Okay, so why don't I start with you and the legal questions? And I'm looking at the buck sheet, and you've included under applicable law the language that was added, the guidelines that were added under the Next Generation Energy Act.
Yes.
And we had issued an order earlier this year that said that the NGEA did not apply to STRIDE 3, and this project is under STRIDE 3, correct? That it doesn't apply to ongoing work. So why was this language added? Because there are projects within the project list that are not ongoing or not considered ongoing as of the date that we issued the order.
Sure. The reason why I put all of that in there is to just be totally clear in case the body had any questions of when new language was added or when it wasn't added. But I think that all of I've just asked Mr. Tesfaye, all of the 2025 projects they're ongoing. Yeah.
All the 2025 projects, they were already approved before the NGA was a law. So,
Right, so I just want to be clear, so every project, because there's a lot of projects in that project list that the company provided,
Correct.
every single one of those projects, staff considers ongoing?
You mean now, let me clear the timing. You're talking about from the timing when the NGA became a law and afterwards or before?
Oh, okay, so we made the distinction in the February order between ongoing, where the NGEA would not apply,
Correct.
and new projects that were not considered ongoing. And I just want to be clear, from staff's review of all of the project list, every one of those projects is considered ongoing. So the NGEA guidance would not apply.
Yeah, yes, I think. Correct. They are ongoing.
And just as a reminder, there is a provision that was already in law that we talked about that said at any time the commission can review a previously approved plan. So you do have that provision, and that didn't change. That was already in the statute. And I'm sorry this is confusing. I can see I can see that coming through. But these are projects that had already been started. I'll put it that way. There was already some money spent on them, as our understanding from the information from the company.
Okay, so I just want to make clear that from staff's position, when we're talking about application of the new guidance from the Next Generation Energy Act, they would not apply to any of the projects on the project list.
Well, in fact, some of them could, because I think what Mr. Tesfaye has been saying in subsequent filings this past year, there have been many, is that staff already used those standards to evaluate the projects. And those standards were already passed. And again, I know this is confusing, and I just need to. That was for 2026. I'm sorry. So 2025, definitely. Yeah.
I'm sorry,
No, I'm sorry too.
Yeah, so the 2025, the NGA requirements added to the STRIDE review process, they cannot start or begin in August. They have to start by the time when the company filed the 2025 Stride project list, that was in December 2024. So just to be clear, the technical aspect of, reviewing those requirements, it doesn't come after the NGA was launched. These projects were already in process, ongoing. They were approved in 2024. So we clearly said, in my opinion, the NGA doesn't affect the 2025 project, but those beyond that, because NGA should be evaluated by the time when the because what does NGA add to the Stride review process? It added that the company should provide information like cost effectiveness of the project.
Okay.
So it cannot be in August. It has to be when was the projects were designed in December, and also other factors. So yeah, we just need to be very cautious.
Okay, well, I just needed some clarity because I wasn't sure why this language was added. So as far as staff is concerned, notwithstanding the guidance that was added, you did not apply the guidance to your review of the projects in this project list.
Correct.
Okay, but what did you look at?
Engineering always look at the standard process we have been doing since 2014. So first of all, as a company file, we go through the eligibility. Every project should be Stride eligible, should be able to reduce greenhouse gas emission, and also bring benefit to the customers and increase reliability and safety to the customer. All these benefits. So starting from the eligibility of the materials themselves, which are added in the project, there are specific type of vintage materials which the company has always included in their project list. That's what we are looking at.
Okay, and did you look at variances?
Yes, of course. That's yes. How this is the checking point for the cost. Yes.
Okay, and were there any projects that you looked at that raised concerns with you in terms of variance?
That's a very good question. We have been always engineering saying, and we need to be clarified with that. We don't have any problem to enforce compliance on any of the laws, but the structure of the Stride itself, the law says the company has to present the plan, which we review based on the Stride law. Then we have a prescribed order made by the working group when Stride was initiated to control the cost. They say, they came up with a cost variance reporting, specifically prescribed percentage-wise, if the project exceed its estimated cost by this percent, do this. By this percent, do this. That's what we strictly following.
Okay, and did you identify any concerns in terms of variances that you're seeing now in the project list?
As I say, the working group prescribed guidelines says that if the project, for example, exceed 10%, the recommendation given is that the company should submit a reason why. That's why we are looking at. Okay, if it exceeds 20 or 50% under a certain threshold, again, the working group recommendation was to provide the company additional information by cost category. So when I reviewed that information, I followed the guideline for Stride and asked the company to submit. I do not have any mechanism beyond that.
And did you identify projects that did exceed the 10%?
Correct. Always we do, yes.
Okay, and then the company provided you with explanations?
Oh, yes.
Okay, and then what do you do with those explanations?
Yeah, that's a good question. That's what we follow the guidelines. The guideline for working group says that we want the company, if it exceeds this, provide additional information or, cost by category. That's all. It doesn't say what to do next, how to penalize. So we need to have a very clear prescribed guideline because we are engineers. My concern is pipeline safety. I'm not economics engineer.
Okay,
Right.
so once you get that information, you're done.
Yes.
Okay.
Correct.
And then do you feel like you have any authority when the project list comes in to go back to the company and say, we have a problem with this proposed project, either because we don't think that it's providing any safety or it's much too costly?
Yeah, okay, so safety, yes. If I have a concern, 100% I am invested in safety. There is no compromise on safety from my side or
Okay.
from the engineering
But
side.
what about if it's too
But we're
costly?
talking about the cost. We follow the guideline, what is prescribed to do with the cost, right? The STRIDE project is approved for 5 years with a specific cost and a specific mileage and service numbers. This is my rail guard, okay? So I keep my eyes, okay, because if let's say the budget approved was like 60 million and the company is spending 80 million, that's where I have a problem,
Right.
right? But as far as the company is within the approved budget, my guideline for cost control is a document provided by the working group which prescribed based on a certain point what to do. That's what I have to fulfill.
Okay, so that I understand, there's really nothing you can do. One, if you identify a project that is exceeding the budget, there's nothing you can do except to just note it
If it's
in the file.
exceeding the budget, I involve on that.
You do what?
I do involve on that. At that point, yes, I have a concern.
Okay.
If it is exceeding the budget.
But what can you do?
What can I do? Because, for example, if the company is spending 70 million, right, and the budget was 60 million, I'm going to disapprove the 10 million.
You can do that in the project list.
Yeah, I think, that is very logical, yes. That's,
And have you done that with any of the projects that are on this project
if
list?
it was any, yes, I would do that. I wouldn't.
Yeah, no,
hesitate.
but did you do that?
When?
For this project list?
No, there is no any concern because I already put in a staff recommendation my findings.
Oh, okay, so none of the projects exceeded the 10% threshold?
They exceeded, there are.
Okay, I guess I'm still a little confused. So,
Budget and the project cost, two different things.
okay, so what happens when they've exceeded the cost that they had identified as what they would spend for a project?
So
What do
yes,
you do at that point?
Yes, so I'm going to open the recommendation of the working group. What does it say? Okay, calculate by how much the company is exceeding. For example, if it exceeds by 10%, then what is prescribed in it? I'm going to read and see that, ask the company additional information for why. That's all. That's it. There is no any other prescribed method or anything, any mechanism following that. Yeah, of course we have if we have any concern, we bring it to the commission.
Okay, but you can't go back to the company and say, you're exceeding the amount that you had said you were going to spend on that project, stop spending so much money?
Yes, I do, and they give me information. I have to make sure I get that information.
Okay, but then once you get that information, what can you do with that?
Yeah, that's a good question again. I'm going to go through the working group recommendation and follow and enforce that. Yeah, of course, good point. So if the company doesn't agree, right? If, for example, they exceeded by 20%. They have to provide me the cost breakdown by the category spent. If they are not giving me, I bring it to the commission.
Okay, so, but you haven't had to do that with this project?
I haven't. I received. If I had, definitely you would see it in my reports.
Okay, all right, thank you. That's all I have.
Thank you.
I have to say, that was a very useful primer for me, to just know how the mechanics works. Any other questions for staff? Seeing none, we'll proceed to, I see our friend from People's Council is standing up. Why don't we? Yeah.
All right, good morning, Mr. Chairman, Commissioners. Ryan Shu on behalf of OPC. We filed a letter on this, not necessarily to take issue with the particulars of the instant filing with the 2025 annual report, but what we provided is an analysis for the Commission's information regarding WGL Stride unit costs over the years. We had one of our experts take a look at essentially, how much is it costing per mile for mains, per service estimates, based on WGL's historical, looking at WGL's past annual and semi-annual Stride reports going back to 2019, which was, I think, the second year of Stride 2, or the first year of Stride 2. And so you can see that, essentially cost per units are increasing pretty dramatically and so the data set only covers projects that are labeled as closed in WGL's system. So for 2025, there's fewer projects that are formally there are fewer projects that started in 2025 that are formally labeled as closed. How the analysis worked was essentially because projects can span different years, we essentially said, when did the project start? And so if it started in 2019, we're going to file that under 2019, even if it closed in 2022 or something, right? I just made that up. But in short, we've seen increases in terms of mains cost per mile from about 2.3 million per mile in 2019 to, with a limited data set, 4.4 million per mile in 2025. Cost per service, we also asked WGL for data response, or we asked discovery of them, and they provided information regarding the cost per service for 2025. Stride cost per service replacements for 2025. Their data set indicated that the per service cost ranged from somewhere between 13,000 per service to 77.8 thousand per service, depending on the project. I can explain that further if you would like me to. And but based on the way the data was presented, it was essentially that it took a project and said this project cost $1 million and it replaced 50 services, say, and it just sort of applied every $1 million divided by 50 was applied to as the per cost service for every single service in that project. And that's sort of how the data was broken out. That doesn't necessarily account for certain services in that project may have been cheaper than others. Some may have been bigger, some may have been smaller, and so we had our expert do a sort of rough analysis to estimate, to sort of, rather than bulk averaging, to sort of break out the possibility that some services may have been cheaper in certain projects and may have been larger, but then you don't necessarily see that when you just take a bulk average. And so under that analysis indicates that per service costs could be between 10,000 per service and 122,000 per service. All this is preliminary, and we're still analyzing the data, but we just wanted to sort of note it for the commission. And again, we're not necessarily asking you to take any particular action with regard to this item, but wanted to raise this for the commission. So if you have any questions, I'm open.
Thank you. Any questions for People's Council? Seeing none, thank you very much. Let's turn to the company.
Thank you, Mr. Chair and Commissioner Spencer Nichols again on behalf of Washington Gas. Thanking staff again for its review of our 2025 annual report. Just to briefly summarize what you already heard from Mr. Tesfaye, as shown in our filing, the company completed in 2025 102% of its estimated mains, 97% of its estimated services, at 101% of its estimated budget. As of December 31st, 116 projects, or 94%, were pipe complete, and for projects closed in 2025, the overall cost variance was within 4% of the estimates. With respect to OBC's comments, I would just essentially object. This is an issue that OPC just raised 2 days ago, less than 2 days ago. So to the extent that OPC wants to raise an issue with a particular project, at which Mr. Tesfaye explained no party has, we just haven't had the time to address that issue. So other than that, we are here to answer questions.
Thank you. Any questions for the company? Commissioner Suchman.
Good morning, Mr. Nichols. Just a very quick question. So for the list of projects that are contained in your filing, are all of those considered ongoing projects or ongoing work for the company?
And I'm glad you asked that, Commissioner Suchman. One point of clarification that I think may be omitted from your question, there was a subsequent order to the ongoing order to the issue that dealt with the term ongoing, in which the commission decided to get rid of that standard of ongoing and just say we are going to continue with the projects on the 2026 project list until that time where we have this rulemaking regarding standards for compliance with the NGEA.
Okay, thank you. I mean, I probably was just looking, I mean, I was sort of going back and trying mostly I was trying to get a sense, again, to try to remember when we were ready to apply the criteria. And so from the company's position, you don't think we're ready to apply the criteria to your project list?
Correct.
Okay, so when will the criteria be applied? What project list will that be?
It depends on the timing and results of the rulemaking 95 that the commission ordered, and I believe the commission is expecting some regulations later this month, some proposed regulations. So it'll depend on the timing of that issue, which the commission, I think, recognized in the order that was issued just yesterday.
Okay, so that would mean that the next project list would be when?
The project lists, and correct me if I'm wrong, are generally filed on November 1st of each year.
Okay, so assuming the new regulations are in effect, that project list will include the criteria such as alternatives.
It depends on the timing. Based on the timing, it depends how much time the company would have to try to apply these new standards that don't yet exist. So if the regulations that result from Rulemaking 95 aren't in place until November or later, then in that case, we would not be able to adjust the list.
I appreciate that. I'm mostly just trying to get a sense of when you think
The
that
earliest,
these new...
I think the earliest would be in 2020 for the 2028 project.
Okay, great. Thank you.
Okay, any further questions? Seeing none, we'll proceed. Sure, go ahead. You get a very small little bite at the apple.
Yeah, on that matter, I would suggest that the commission potentially ask WGL to postpone its, if it looks like the RM95 regulations are going to take a while and won't be in place in time for WGL to apply it to the 2027 project list, we would strongly suggest that the commission consider asking WGL to postpone the project list until they can meet the criteria established in RM95. Thank you.
Okay, noted. We'll proceed to a vote. Commissioner McLean. Aye. Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Hoover.
Aye.
Chairman votes aye. The motion is carries unanimously. Item number 5, PEPCO, proposed tariff implementing distribution rates. This is for the rate case number 9820, and the staff recommendation is to reject the tariff as filed. Let me turn to Ms. Herman.
Good morning, Chairman Barve and Commissioners. Ruthie Herman on behalf of staff. Staff's comments, my comments from the podium today will just emphasize what we said in the buck sheet. And I'd like to add some additional information, and particularly an order from case number 9655, which may be helpful. I want to know if, I'd first like to hand it to Ms. Curry, but could Mr. McAuliffe approach the executive secretary?
Sure. Yes, absolutely.
In addition, I'm, as you see, Drew McAuliffe. Pardon. Yes. Do you have a copy for OPC? Yeah. Get one back from her. He'll get one back from her. I'm sorry. Case number 9655. Yes, and as you can see, Drew McAuliffe, Director of the Electricity Division, is here. We recommend that the commission. Oh, I'll wait. Yeah. And what we're passing around, and I'm sorry, OPC will get, is the order related to this from PEPCO's case number 9655, where PEPCO brought to the commission their request that the statute be waived and not allow the dates, the suspension to expire according to statute, but an additional 5 weeks for the reasons they included in there. It was jointly proposed, staff co-signed it, and it was approved by the commission. That was not in our buck sheet, so we wanted to make sure that you had the benefit of that information. Yes, staff does recommend that the commission reject the proposed tariff. They're cumbersome, it's confusing, it's not transparent, and it's not required by law. You're not legally required to accept the tariff. It is legal to waive that applicable statute. The commission did it before. And the circumstances, it was a longer period of time. It was 5 weeks, not the 18 days in this case. Statutes can be waived. Constitutional rights are waived. Anybody who's ever defended a criminal case in a state court of law, when a plea has been entered, knows that the judge instructs the attorney to please advise your client. And then what you do is you turn to your client and you say, you pull it out of a laminated card in your briefcase, and you say, do you knowingly, voluntarily, and willingly waive your right to a trial by a jury of your peers? If you can waive a constitutional right, you can certainly waive a statute. So the argument that a statute can't be waived is actually incorrect. And in particular, this statute was waived, and there have been no objections. That was a couple of years ago. I have a case. This wasn't in my comments. I'd like to just read the case name, that's all, for those who are listening at home. Smith v. Wakefield. It is a Maryland appellate case, and the numbers are 462 MD 713. That's Smith v. Wakefield, 462 MD 713. And the relevance of Smith v. Wakefield is that it gives a long discussion of when a particular statute can be waived. In this case, it's the statute of limitations, which is Courts and Judicial Proceedings Article 5-101. It talks about when it can be waived, can it be waived, and in connection with Real Property Article 8-808. Ultimately, the court held that that statute of limitations is not subject to waiver, so it can't be waived. Well, we don't have that here. There's no case where anyone has evaluated and said, well, that statute cannot be waived, or under these circumstances. And this body did waive it. So an assertion that the statute can't be waived is just is actually incorrect. Child support. Child support can't be waived. There's statutes in the Family Law article that the cases, I can give you in re-marriage of Hauser, 489 MD 244. It shows the body that under certain specific situations, there are certain aspects of a statute that can't be waived under certain circumstances. But again, the assertion that a statute can't be waived is incorrect, and particularly this statute. So oddly about this tariff is that it's meant to comply with 4204, which says that the proposed rate must be suspended or can be suspended. Well, the problem with the proposed tariff is it actually doesn't suspend the rate that was filed, because when the company filed the case, you could just look at the cover letter. It says 133 million future forecast test year. And then if you dig a little further, you can see a rate of 142 million if it was the traditional compliance test year. So, but in the company's proposed tariff, they don't cite that rate, they cite a rate that was calculated upon rebuttal by their witness, 119.4. So they're not even addressing the rate that was suspended. The commission wouldn't have known about 119.4 when it was suspended. And just on the point about whether the company was judicially estopped or not from filing this, it doesn't really matter what a doctrine you apply. The concept is that this body, when it was deliberating and asking the company and other parties questions, it took into account and relied upon the statements by the parties when it made its decision and ultimately decided to extend by 18 days the effective date, the effective implementation of rates. PEPCO can't then come back 2 weeks later and say, we forgot something. It's human to forget things. Everyone does it. But you don't get to rewrite what happened. The body relied upon what they said. And if that weren't true, well, none of the orders would have any meaning and you would have chaos. On the last point is PEPCO argues that the case couldn't have been confusing because parties were able to recommend a revenue requirement. And I take exception to that because we have on staff highly experienced regulatory accountants. And it took them months and months and months to decipher the case. And actually, the confusing and conflicting documentation is a matter of public record. Just to conclude, we recommend that the Commission reject the proposed tariff. It's flawed. It's not required. It's confusing. And it's not necessary. Thank you.
Thank you. Questions from Ms. Herman?
Yes, I have some.
Commissioner McLean.
Ms. Herman, so if we reject the tariff, what happens to the rates? Are they continued, the suspension continues?
Yes, it would just continue. And your order of May 4th remains in effect, that the current rates remain in effect until the 28th. And then whatever you order in your order on the 28th, those are implemented. And then I believe they would file complaints tariff. Yeah, the company would then file complaints tariff.
And is your position based on the interchange at the, during the, excuse me, during the last day of the rate case?
Yes, sir.
But would you also agree that we can't extend the, excuse me here, we can't extend the statutory period, suspension period without PEPCO's consent, or do you think we can do that on our own?
No, I think you need their consent, and you had it.
All right,
Actually, I'm going to take back on that. I'm not sure, but I would say under this circumstance, you had it. They voluntarily agreed, and that was the question that went out to them. And I was just looking at the dialogue in the last couple of days. So yeah, I want to be clear. You had their voluntary agreement, and that's why. And you relied upon that in making your decision. Whether you could do it without theirs, I haven't thought that through. I just actually don't know. But in this case, and I see the word voluntarily so many times, and I see that I'm not the only one that mentioned the statute. It was Commissioner Hoover who mentioned the statute. So, and PEPCO's a sophisticated party. They clearly understood what we were talking about. Now, if they forgot about 9655, they may have just forgotten. But the body did it before.
We did it before, but that was with the consent of the utility, correct?
They proposed it.
Right.
Yes, they
Right.
proposed it, yes. So it is a little different here. But here it clearly was voluntary. They were asked for. And I would imagine their position, their thinking may have been otherwise they might, there might be some unfortunate consequences that they didn't want. I don't know. I don't know what they were thinking. But they did voluntarily. I think when you examine the dialogue and what's in the transcript, they agreed to it. And, we also have extensive case law that says when you don't object to something and you don't object when it happened, you have agreed to it. And I think that's, we're talking about a sophisticated party.
Thank you.
Commissioner Linton.
Thank you, Mr. Chairman, and good morning. Commissioner McLean actually asked two of my questions, but I had another question for you. I just want to make sure we're all, and by all I mean the People's Council, the company, and the staff, and of course all of us as commissioners, are on the same page about what's being asked for here. Because it sounded at one point like staff thought the company was requesting the proposed revenue requirement from the rebuttal testimony of one of the witnesses, that's what would go into effect as opposed to what is currently the rates until the commission issues an order changing the rate. So I believe those are two different numbers. Which one is it that you expect is being proposed here today for this tariff that you're suggesting we reject?
So, good morning, Mr. Chair and Commissioners. Drew McAuliffe on behalf of staff. So the company is proposing to put in their rebuttal rates in effect on August 11th, but they will, at the same time, include that rider, which will negate it and collect what their current rates are. But so, as Ms. Herman stated, they're not filing their originally proposed rates in the case. These rates have changed, and came from rebuttal. So that's why we disagree with the operation of law, because this wasn't and the suspension period. This wasn't their originally even filed rates. They changed them. So they filed their rebuttal rates and revenue requirement, but they will have a credit to all customers to cancel it out. So, for example, the residential customer charge, for each component of the rate too. So the residential customer charge, in their rebuttal was proposed to be $867. It's currently $844. So effective August 11th, the rate will be $867, but then they'll have this rider RDM, which will be a credit of 23 cents, the difference between the two rates.
So is the effect of that the rate stays the same? It stays what was originally initiated or offered in which case was that? 9702, I think it was?
Yes, but so staff's concern is that, but then on November 1st, after the commission issues its final order in 9820, the company then will request to collect what they believe is an under collection from August 11th through August 27th through this rider. So they're gonna essentially keep so that's why we think this also overly complicated. We think they could have just kept the rates the same, and then just say you agree with the company that they should get their rates August 11th. They could have just included a rider when they filed a compliance filing on August 28th instead of making it extra complicated with this filing. So they're gonna net out that difference, so effectively no rate change. But then when you issue your order on August 28th, whatever the revenue requirement increase is, just say it's $50 million, they're going to then collect that 17-day period, whatever the amount that revenue comes out to be from that $50 million that they missed out on, and then we'll collect that from customers from November through December of this year.
So I don't know what that number is going to be, of course.
Right.
And if I did, I wouldn't say. What would the staff, again, you don't know the number either, but what would you have expected to have happened with that number, with that extra revenue? When would they have collected it?
If they didn't make a filing?
If they didn't make a filing, yeah.
So, I mean, there could be multiple ways. I think you could have used the BSA for non-BSA classes, just included that in the deferral mechanism. That would have been a lot simpler. And then for non-BSA classes, you just include an extra $5, $10, whatever the number is for a couple months. So yeah, I think there's multiple ways you could have done it. But yeah, that's why we just think this is just overly complicated. Because it shouldn't be a large amount, obviously. It's only 17 days. It's not 3, 4.
Right. So, just one last question, Mr. Chairman.
Sure.
Did you anticipate that when the company, and I'm not getting into the estoppel and some of the other arguments, but was it your understanding that when the company, as you perceived it, that the company waived the date for implementation of this new rate, that they were in effect waiving the revenue that they could have recovered at the same time? Or are you suggesting that, is that what your understanding was?
That's what our understanding was. Frankly, I don't think staff would have agreed to the changing of briefing schedules if we thought the effective date was the same. Because it just, again, overcomplicates things.
Okay. All right.
So, as Mr. Spivak wanted me to reiterate, yeah, we don't agree that they should collect this 17 days.
Okay, so that's really what we're talking about
Yes,
here.
that is
It's
the
not,
issue.
it's not a question of the mechanism.
No,
It's-
not
it's-
per, we think it's
the staff,
overly burdensome, but yes, it's the main issue is that 17 days. Yes.
right, your position is that they waived the, I'll call it the right
Correct.
to collect that 17 days because they agreed to the waiver.
Correct.
Gotcha.
That is our position.
All right, thank you. Thank you, Mr. Chairman.
Commissioner Suchman?
Okay, so notwithstanding the fact that you believe they've waived the right to collect that sort of amount, whatever, assuming, of course, that we allow them to increase their rates. I guess if we actually decrease, I don't know what, but assuming we're going in that direction, and they elect to try to use the BSA to recover that 17-day period, would staff have an issue with that?
So we don't think they should collect it at all. But so if the commission says they should be able to, I'm just saying there are other avenues, that this isn't necessarily the only avenue to do so.
Well, there are other avenues that they could have argued after the fact, but you still would have objected to their using that because you believe that they've waived that
Yes.
17-day period. Okay,
Correct.
thank you.
Any other questions? Okay, thank you. I see People's Counsel is up, so I presume you want to weigh in here?
Yes, Your Honor. Thank you, Mr. Chairman. Michael Sammartino on behalf of the People's Council. I had some brief remarks prepared, but this new document staff circulated earlier, we're still trying to understand staff's position here. I'll say that, as our comments note, we think the law itself is pretty clear. When the commission is once a proposed rate is filed with an effective date, the statute takes effect, and under the current law, that rate goes into effect by operation of law once the suspension period ends. In reviewing the proposal, the filing dated January 11th, 2021, it looks like the extension in that case was effectuated through PEPCO agreeing to amend the proposed effective date of the rates that it originally filed. And by amending the proposed effective date, that allowed the commission to then, for lack of a better phrasing, reset the clock on the rate suspension period. So I think if PEPCO were to voluntarily amend the proposed effective date of the rates that it filed in 9820, the commission might be able to authorize a different rate suspension period. And in that case, the rates would not, PEPCO's proposed rates wouldn't go into effect, and then the rates that the commission authorizes in a final order might go into effect. But to the extent that this adds further confusion to the commission, this might be an opportunity for subsequent comments filed by the parties on this approach.
Questions for People's Counsel? Linton, then Suchman in that order.
Yes, good morning. So just following up on the last question that I asked the technical staff, the People's Counsel, did you understand that the company to have waived their right to collect during the revenue during the suspension period that was not being addressed?
So, to be frank, I was a little. That's what I understood counsel to represent. But then I also, when I looked at the statute, I wasn't sure how they could do that, given the statute's clear with when the proposed rates go into effect. So I was not sure. My expectation was PEPCO would make a filing similar to what it did in 9702, and that's what the company did. But I can understand, staff counsel's reading of the transcript. I think counsel could have been more clear about what the company was agreeing to and what it didn't.
Which counsel are you referring to?
PEPCO counsel. Yeah.
Okay.
All right, thank you. That's all I had.
Commissioner Suchman.
Okay, so I'm instituting my Wayback Machine. We've had conversations. Only people who are older can understand why. And I'm trying to remember that it was a Friday evening, and it was late, and we were exhausted, and we were finished with the case, and we were having a conversation about briefing schedules, and we were also having a conversation about I had asked a bench request for the company to provide us with a lot of information. And I remember Ms. Francis being concerned about information coming in that hadn't been in the record. So there was a lot of different moving parts going on. And we moved the date in which we were going to issue our order in order to provide parties with sufficient time to be able to do their briefing schedules. And so I'm going to have to go back and look at the record, but it's with all of those moving parts, if the company had made an error and thought that they were agreeing to something that they hadn't agreed to, I find it really hard to hold them to that. And I don't know if you went back, and I actually did not go back and look at the record, but I think I actually am going to need to go back and look, because I'm not really clear that we were all operating on all cylinders at that moment, because it was Friday night and we had been in hearings all week, and so I guess it's hard for me to imagine that the company would waive 17 days of revenue just so that we could go home. I'm finding that hard
Do you have a
to.
question for the?
No, so I guess, yeah, I often have a problem with so you were there, and was it your sense that the company was waiving that 17 days of additional revenue?
I would have thought it odd if council had made that proposal to the
Okay,
commission.
thank you. That's all I have.
Any other questions for People's Counsel? Okay, we'll turn then to the company. Ms. Curry.
Good morning, Chairman, Commissioners. Just a few things that staff raised just now. One, that there's the ability of the commission to waive a statute. The laws are passed by the General Assembly, and the General Assembly are the only ones who can change the law. So staff's contention that somehow the commission can decide on its own to change laws is not in basis, it has no basis in any law that I'm aware of. Another question was asked of what happens if the commission rejects the tariff. If the commission rejects the tariff, our rates go into effect as we filed them. That would be, and that is due to operation of the law. The rates go into effect as we file them on August 11th. There's been another contention that we're using the rates from our rebuttal testimony, which is, I believe, a lower number for our TTY than what was in our original filing, and that somehow that can reset the clock. Think about the precedent that would set. How often in rebuttal do parties come back? They look at information that's been provided in DRs. They review information that the parties raise in direct testimony. How would that throw rate proceedings into chaos if that automatically reset the rate effective period based on changes in the numbers and the revenue requirement in the rebuttal phase? So we disagree that resets the clock. Staff also mentioned that had they known that we were going to seek recovery of our charges for those 2.5 weeks, that they would not have agreed to the extension, which is surprising because the extension benefits them. It gives them the additional time to write their briefs, which is what they were asking for. So it's surprising that they would say today that they would not agree to an extension of time that we were willingly giving them. And just to highlight the benefits of the RDM, there's been some conversation about, is it the best thing, the best way to accomplish what we're trying to do here? Everybody wins under the RDM. The parties get the additional time to brief. The commission gets the additional time to write the order. The commission can comply with the PUA because the rates will go into effect in accordance with the law. Customers are not harmed. They won't experience a rate increase. So it's a win for everyone. So it is the ideal option. Staff's estoppel argument was, again, another surprising element of their comments. There they were arguing that there was a comment made at the hearing and that I did not immediately challenge that comment. And somehow that commits us to not recover any charges for that 2.5 weeks of additional time that were given. That's not supported by the law or the facts. It's not supported by the law because the information or the law that staff cited in their own comments has certain criteria you have to meet that estoppel guideline. You become estopped after you meet these particular criteria. One, prejudice to parties. Another one is intent to mislead. As I mentioned, there's no prejudice to parties. Everyone wins under the RDM. And two, there was no intention to mislead. The staff is also wrong on the facts. During that time when I was originally asked, are you willing to voluntarily extend the schedule? I said yes. We were talking about extending briefing. We were talking about extending the order. I cannot find in the transcript, and I looked, where we agreed to give up 2.5 weeks of revenue. We agreed to show the grace to the parties and the commission and extend the time, but there's no place in the transcript where we agreed to give up the right to that revenue. It's not in there. Finally, I'd like to say the reason why PEPCO transitioned its case from an FFTY to a TTY was not due to our own choosing. It was the consequence of legislation. It was the consequence of the Relief Act. And staff wants to take the position that we should somehow be punished because we had to transition our case from an FFTY to a TTY. This kind of falls under the no good deed goes unpunished category. We were trying to show grace, extend the time to allow the parties the additional time to consider their briefs. And this is consistent with what we've done in 9702. And when staff was talking about 9702, the RDM being confusing, we implemented this in 9702. So we're able to successfully implement this model. But in 9702 and here, we've shown that we're willing to work with the parties. We have not come to parties with any type of malicious intent. We demonstrated in our words and actions that we're willing to work with the parties. So it is surprising that staff's reaction is to essentially want to penalize us by denying this revenue for 2.5 weeks because we elected to extend the time period. So, and at 9655, I'm seeing this for the first time, but I cannot see where we agreed to give up revenue. I just have a couple of items here, just as the revised procedural schedule and then another document here about extending the procedural schedule. I don't see anything kind of, if any tariffs were filed or anything like that. So I really can't necessarily speak to this. I don't know what staff was using this for, offering this for, without the subsequent history as well. So, but any event, as I mentioned, the law is what controls here. The PUA says the rates go into effect on August 11th, so they have to go into effect on August 11th. Absent RDM, they will go into effect. So I'll leave it there and I'll open myself for questions.
Commissioner McLean.
Good morning, ma'am. How are you?
I'm fine, thank you.
If you recall from the end of the hearing, I asked you a question about it. I'm sure you probably don't have it in front of you, so I'll just read it. It says, Ms. Curry, is it fair to assume that the company will make some kind of filing that deems your proposed tariffs filed 20 days later? That's how I've typically seen it done when there's an extension to the suspension period. You responded, I believe that's what we did in 9702. We had to make some level of filing so that the rates didn't go into effect because they'll automatically go into effect after 300 days. I'm fairly certain we'll have to do that. So based on that question and answer, what was your intent at that point in time to file this new tariff, or because I understood that you were just going to extend the suspension period?
I was focused there on, we have to file something to keep the rates from going into effect, which is what this tariff does. It puts the rates in effect, but then offers an offsetting credit. So that's what I was referring to there, is that mechanism. But in that exchange, if I recall correctly, I didn't speak about waiving the ability to recover that 2.5 weeks worth of revenue. It was really just talking about that mechanism to address the PUA's demand that the rates go into effect on August 11th.
Sure, but if you extend the suspension period, the additional revenue is not an issue, correct?
If I extend the extension
Or
period,
if you extend the suspension period.
I don't think I can. That's the thing. I don't know if we can do that. So the PUA says you can only extend the suspension period 300 days after filing, and that would be August 10th.
Sure, and like I said, what I've seen has been done typically when there needs to be an extension period. The utility would file a letter saying, okay, please deem our tariffs filed 20 days later. So that effectively extends the suspension period, or it resets it, and there's no issue of revenue.
That is not what I intended there. So filing a letter saying, hey, we really didn't file on October 14th. We filed 20 days later.
Exactly.
Yeah, the only thing about that is RDM feels to me more consistent with the statute, right? The rates go into effect as the statute requires. That feels a little bit more, I don't want to say circumventing the statute, but it doesn't feel very direct. What RDM does is preserve the statute as is without kind of more smoke and mirrors as kind of trying to change effective dates. RDM allows the rates to go into effect with the offsetting credits, and it's a more direct response to the statute. That's why I would prefer it.
Okay. All right. Thank you, ma'am.
Commissioner Linton, Suchman, and then the chairman. Okay.
I'm sorry?
Go ahead, Obi.
Okay, thank you. Good morning.
Good morning.
So just to be clear then, and I think you've already said this, but just so the record's clear, the company did not intend to waive the revenue for this, the extended period.
That is correct. We did not intend to waive that ability to recover those charges for that period.
Okay, so it appears then that the question that we're dealing with now is what type of mechanism we need to use in order to cover that extension period. So was there any effort from either the company's part, or I guess it falls on the parties as well, but was there any effort to try and resolve that, to talk about the best mechanism to use of any kind?
No, because 9702 we did this, right? Same parties were involved in 9702 as this one. So really there'd be no need to do that. But there's not a whole lot of things we can do. RDM accomplishes what we want to do. As I mentioned, all parties benefit. It's a tried and true mechanism. We did it in 9702. And so there's not a ton of mechanisms that we can do to preserve our ability to recover that 2.5 weeks worth of lost revenue. So the long way of answering your question is no. This mechanism works. Everyone benefits. It's ideal for that purpose.
So the mechanism that you're proposing here today, then, just so the record's clear, there is no, aside from the numbers, of course, there's no mechanism-wise distinguishing difference between what was done in 9702 and what you filed here.
Is there any difference between the two?
And again, I'm not talking numbers.
No, there is not. That is correct. There is not.
All right. All right. That's all I have. Thank you.
Commissioner Suchman.
So for this RDM, you have the software in place to do this.
The software in place to do it.
Basically,
yes.
I'm
Yes, we
asking
do.
if there's any cost of implementation.
There should not be any IT costs because it's kind of, again, the rates go into effect with the credit. We've done it before, but let me just double check that beforehand. There
That's
was
fine.
not,
That's fine.
an additional cost. I don't recall there being additional costs the last time around. I don't recall us asking for additional cost recovery for that. So I would anticipate the same here.
Okay. And did
correct.
you got confirmation? So no additional cost.
No additional cost.
Okay. Thank you.
Commissioner Hoover?
No, I
Okay. This was my first instance of running a rate case, and I remember it pretty clearly. I can really see people right now in my mind's eye. I did. Well, Ms. Curry, I remember you saying something to the effect that you were going to voluntarily allow us extra time to do the case. And I haven't read the transcript fully, but I don't believe you ever mentioned anything like this with respect to recouping the 17 days lost revenue. Do you remember saying anything to the effect of we're going to ask to be made whole or to be held harmless? Or do you recall using any language like that during that?
No, I did not. But it's kind of assumed by the law, and giving up that level of revenue should be something that should be affirmatively stated. And I've looked at the transcript, and that affirmative statement is not in there.
Okay. All right. Are you saying, I was listening to the exchange with one of the commissioners. Are you saying that the company does not have the ability to grant an extension of the timeline without compensation?
No, we are not allowed to do that. The statute says, that the rates have to go into effect on August 11th. The statute does not say that we cannot give up that those charges.
Does the statute say that, or does the statute say that the commission has to rule by that date?
Order has to be issued at the end of the suspension period. That's the way it's phrased.
Of course, I was never on the committee that did any of this, but I presume that these timelines were done for the benefit of the utilities so that these cases wouldn't be dragged out indefinitely. Is that a fair assumption?
Maybe a due process argument. It might not just be for the utilities. It might be for customers as well. Rate certainty, that sort of thing. But, happened a long time ago.
Did you, I seem to remember you saying, and again, I haven't gone back and read everything, that you would voluntarily extend the timeline by, in effect, 17 days.
Yes.
So what's your understanding of the definition of the word voluntary?
Voluntarily extend the briefing and the order. That statement did not include a voluntarily giving up of revenue. So to answer your question.
So you're saying that the word voluntary has a different meaning legally than it does in the dictionary.
Not legally, and it does in the dictionary. We're talking about two separate things. What I understood your ask to me was, can we voluntarily move the briefing date? The answer to that question is yes, we can decide to do that. There's a separate question that relates to compensation. So there's the question about voluntarily moving the dates, which we can do, but then there's the second part about the compensation, and that's where the statute comes in and the rates go into effect after the suspension period if an order has not been issued.
Wait a minute, I thought you just told me that you are not able to voluntarily move the order date, that the law requires us to rule on that time, and then you cannot voluntarily change it. Did I mishear your statement at the beginning?
I'm looking at it as two different things. We can voluntarily, procedurally take an action, but then what we are talking about here is what we do with the revenues, what we do with putting rates into effect. So yes, we can voluntarily move, but at the same time, we want to be compensated for that move. So I look at it as two different things. Voluntary means, yes, we'll extend the order, allow the parties the ability to, get that time, additional time to write the brief. But what is not in the transcript is voluntarily giving up the right to recover for that 2.5 week period of time. And to answer your question, can we voluntarily give up the revenues? I suppose we could, but that's not what we're saying. That's not what we're offering, and we're not volunteering to do that.
I'm going to do something unusual. I'm going to allow staff and OPC to comment on this. Staff.
Thank you, Mr. Chair. Just a quick point of clarification. So in 9655, in order 89687, which we handed to the parties, the operation of law date was extended voluntarily by the company, and all parties agreed. If you read the last sentence, the joint request states that a 5-week extension of the procedural schedule would give all parties additional time. Then if you look at the top of the next page, the joint request includes a revised procedural schedule, rules for discovery, and an extended operational law date. So the fact that the company saying that cannot happen is just incorrect, because the company themselves did this just 4 or 5 years ago. So, thank you.
People's Counsel, any last thoughts?
Yes, Your Honor, thank you. First, I'd just like to correct one misstatement from Pepco Counsel. There is one key distinction between what we all agreed to in 9702 and what the rider proposed here is. The key distinction is the duration of time. In 9702, I think it was like a roughly 3-month delay. So that'd be 3 full billing cycles that customers would have to pay Pepco's proposed rates. So, this is the rider approved in 9702 covered an extension for a 3-month period of time. This rider here is only a 2-week period of time. So I think that's a key distinction. Just wanted to note that for clarity on the record. With respect to the changing of the pushing back the rate suspension period, the company, and as I noted earlier, and I think what Commissioner McLean referred to in his back and forth with Pepco Counsel, Pepco could voluntarily amend its initial filing and change the rate effective date. And that would allow they could push the rate effective date back 17 days, and that would effectuate this change. And by so doing, Pepco would relinquish its entitlement to collect revenues under its proposed rates for that interim period. But if Pepco doesn't voluntarily amend its proposed rate effective date, then the commission is bound by the current rate suspension period termination.
I think Commissioner Suchin wants to ask you a quick question.
Right. Well, and actually maybe also the staff. So would you be amenable to somehow tinkering with the rates so that the suspension period is delayed 17 days, or do you really want to push the argument that they've waived their right to collect during that 17-day period?
believe we'd be okay with that because it's essentially the same thing. So if you just change the effective date back 17 days, they're still not going to get the 17 days.
They're still not going to get the
Yes,
17.
because so if you ask them to file a new tariff pushing the effective date of their rates back 17 days, they are,
No, suspending it, so continuing, suspending the period for 17 days.
to me, that sounds like the same thing. If you just have them file a tariff suspending the effective date for 17 days, that means they're going to forego these 17 days we're talking about of revenue.
I didn't have the sense that that was going to happen. Is that your sense?
So under the statute as it's written, I don't think the commission would be able to extend the suspension period by 17 days. Like the suspension period is, I believe, 270 days for alternative forms of rate making. That said, the commission does have discretionary authority to take that action if it so chose. But the statute explicitly spells out what the suspension period is. I think, for lack of a better phrasing, the workaround that would be PEPCO to voluntarily amend its proposed filing to set the proposed effective date 17 days in the future. But to the extent my reading of the law.
But they would be still foregoing that 17-day period.
Yes. But my reading of the law is that I don't know if the commission could compel the company to amend its initial filing in that way.
Okay, thank you.
Okay, Commissioner, here's what we're going to do. Commissioner Linton, I will then allow the company to have the last word, and then we're going to move on from this. Commissioner Linton.
Thank you, Mr. Chairman. Very, very briefly for staff, your reference to 9655 and on page 2 of the document you distributed, it references an extended operation of law date. Is your position then that once that occurred, we were to take these facts and then layer them onto this situation, it would result in effectively the company waiving that additional revenue for the period that we're talking about?
Yes, because there was no clawback rider in this case. This case had similarities that there was issues with. Anyway, staff found some errors, and instead of having the company completely pull the case, we allowed them to just kind of extend it down the road a bit. So we think it's a similar circumstance where there was issue with the revenue requirement in this case. What's the number? There was changes in law, things like that. So yeah, we think that pushes them back, and they don't get that recovery.
And so during that, okay. All right, that's it. Thank you.
Ms. Curry, you get the last word.
I hear the word voluntary used a lot. We do not want to, we do not voluntarily agree to push our filing back by 2.5 weeks. So hopefully that takes that option off of the table. We do not voluntarily agree to do that.
Well, I've learned my lesson. I need to know what words mean before I agree to anything. We're going to take this under advisement. I want to reread the transcript. I want to confer with our legal experts before we take an action on this.
Just one final word. I mean, one other option is. Okay. Yeah, all right. I'll.
No, we're taking this under advisement. Okay, last item on the agenda. And that's going to be item number 6, Northrop Grumman Systems. It's a request for waiver of gas interruption. The motion is first to grant a reduction of the distribution interruption penalty for the 7323 Aviation Boulevard property by 25% to $26,093.42, and to grant a reduction of the distribution interruption penalty for the 1212 Winterson Road property by 10% to $101,764.31. Let me turn to staff.
Good morning, Chair and Commissioners. Brandon Bowser on behalf of staff. I will note that my comments are a little lengthy. I've done my best to condense them as much as I can. Just wanted to give you a heads up ahead of time. There's just 2 properties here with different sets of circumstances, and there's a lot of really important relevant information. That being said, on March 20, 2026, Northrop Grumman Systems Corporation, or simply Northrop Grumman, filed a request for waiver of the distribution interruption penalties that were imposed by BGE in regard to its failure to stop taking delivery of gas at 2 of its properties in Linthicum, specifically during the January 26th to February 2nd distribution system interruption. The filing, I will note, was originally submitted confidentially, but the company waived the confidentiality of the filing in a May 11th email to me, which you can find in attachment 1 to the buck sheet. I'll also note for anybody in the room and watching online that the mail log has also been made public, so that can be viewed on our website as well. Specifically, the properties in question are located at 7323 Aviation Boulevard and 1212 Winterson Road. BGE imposed a $34,791.22 penalty at the 7323 Aviation Boulevard property and a $113,071.45 penalty at 1212 Winterson Road. Northrop Grumman has requested full waiver of the distribution penalties for both properties, citing a communication failure that occurred with regard to the 7323 Aviation Boulevard property and an inability to fully curtail its usage at 1212 Winterson Road due to some of its critical manufacturing processes that exclusively rely on natural gas being located at that site. Under Section 3.4B of BGE's Schedule IS, or Interruptible Large Volume Service, the Commission may waive or reduce a distribution interruption penalty or excessive use penalty for a customer that demonstrates a good faith effort to interrupt gas usage and substantially reduces its usage during the interruption event. To determine a good faith effort, Section 3.4B sets forth a 4-factor test, which I will detail shortly. For customers that have contracted for optional firm delivery service, or OFDS, Section 3.4b specifies that usage that exceeds 5% of OFDS under contract constitutes prima facie evidence that the customer did not make a good faith effort to comply with the interruption. However, I will note that Northrop Grumman has not contracted for OFDS at either property. Further, any waiver or reduction of the distribution interruption penalty or excessive use penalty shall consider the customer's good faith efforts to interrupt and may not be based solely on the extent to which the customer actually reduced its usage. Any credits granted to customers through the waiver process will result in similar debits to Rider 8 monthly rate adjustment. Schedule IS also requires that customers on an annual basis must either, 1, provide certification from a professional engineer that they have the ability to interrupt when directed by BGE, or 2, participate in a physical interruption test by BGE that assesses the customer's ability to interrupt when called upon. Northrop Grumman explained in response to a staff data request that 2 physical interruption tests were conducted at 7323 Aviation Boulevard, one in November 2025 and one in December 2025. They did not pass the November 2025 test due to a tripped breaker causing a failure of communication between the gas meter and BGE, which necessitated the December test, which they ultimately passed. They did pass the November test at the 1212 Winterson Road property. Staff evaluated Northrop Grumman's efforts under each of the 4 factors for each property, which I will now detail. Factor 1, efforts made prior to interruption. Northrop Grumman explained that it immediately coordinated with its fuel oil provider upon notification of the interruption on January 23rd to ensure timely delivery of fuel throughout the interruption event. Northrop Grumman received 6 deliveries of fuel to the 7323 Aviation Boulevard property and 2 deliveries of fuel oil to the 1212 Winterson Road property. This was throughout the duration of the interruption event. Factor 2, reason why full compliance was not attained. With regard to the 7323 Aviation Boulevard property, Northrop Grumman explained in its filing that there was an unforeseen communication failure regarding BGE's extension of the interruption from February 1st to February 2nd, which resulted in 3 hours of non-compliant gas usage on February 1st. Staff asked for a detailed explanation of this communication failure and related communications with BGE and Northrop Grumman's gas supplier, WGL Energy, in 2 separate data requests. Northrop Grumman explained that it received the initial notice that the interruption was scheduled from WGL Energy via a January 23 email with subject line, quote, interruption notice, 10 a.m. Monday, January 26 until 10 a.m. Sunday, February 1. Northrop Grumman explained in response to staff's first data request that the body of the email contained a discrepancy in the anticipated interruption end time compared to the subject line, stating that the anticipated end was 6 p.m. on February 1st, not at 10 a.m. Staff asked for a copy of this communication in its second request, and upon inspection of the email, can confirm the discrepancy is present as described. This communication is found in Northrop Grumman's Exhibit 3-1 and Attachment 2 to the buck sheet. Staff also asked Northrop Grumman in its second data request whether WGL Energy was contacted to clarify the correct end time. Northrop Grumman responded that it contacted BGE upon the initial January 23 WGL Energy notice to confirm that the interruption was going to happen, but admitted that it did not confirm the anticipated end time with either party. Northrop Grumman explained that it found the text in the subject line anticipating the 10 a.m. February 1st interruption end time was, quote, most prominent and believed to be the ending of the event, end quote. Northrop Grumman also explained that it discovered the inconsistency only after the interruption event when further investigating its communications, and that it believed that this is what caused the circumstances that led to the premature resumption of gas usage. These circumstances are as follows. On January 30th, BGE sent communication that the interruption event was going to be extended to 10 a.m. on February 2nd to Northrop Grumman's primary and secondary contacts for utility matters, which are respectively a manager and an engineer, both in the facilities engineering department. This communication is found in Northrop Grumman's Exhibit 3-2 and Attachment 2 to the buck sheet. Northrop Grumman explained that the primary contact was off on a scheduled 9:80 Friday, and for reference, a 9:80 Friday simply means that over a 2-week work period, the employee works 9 hours per day, resulting in every other Friday or a day of their choosing that they are off. While the secondary contact was also sent this communication by BGE, Northrop Grumman explained that the secondary contact did not forward the notice to the 7323 Aviation Boulevard boiler operator team, as they, quote, reasonably believed that BGE sent the interruption extension notice to all the recipients who received the initial notice of interruption, end quote. The secondary contact is stating that the boiler operators received the initial notice of interruption but did not receive the extension notice from BGE. This resulted in the boiler operators prematurely resuming gas consumption at the property at approximately 10:30 a.m. on February 1st, of which they informed facilities engineering. Facilities engineering replied about an hour later that the interruption had been extended, which caused the boiler operators to immediately revert the boilers to fuel oil. Approximately 3 hours of non-compliant usage occurred, as I previously mentioned. While staff can conclude that it is somewhat reasonable that the facilities engineering team expected BGE to communicate to all parties of record, including the boiler operators, that the interruption was going to be extended, staff does not find this to be an acceptable policy moving forward. Staff strongly urges Northrop Grumman to institute a robust, redundant communication policy that flows all interruption communications from both BGE and WGL Energy to the boiler operators to ensure potential future similar situations do not occur. Turning now to 1212 Winterson Road for Factor 2. Northrop Grumman, in its filing and in its responses to staff data requests, explained that there are several critical manufacturing processes located at 1212 Winterson Road which must rely exclusively on natural gas. They cannot operate on fuel oil. When staff asked Northrop Grumman why this property was on an interruptible tariff in light of this, Northrop Grumman explained that they were informed by BGE that firm service was not available for 1212 Winterson Road due to gas system capacity and pressure constraints. Northrop Grumman also explained that they were unaware of the ability to contact for OFDS, hence why the property was not on it for these processes. Northrop Grumman was, however, able to curtail 91% of the usage at 1212 Winterson Road compared to its average daily usage, as the only two things that could not curtail were those two critical processes. Everything else was able to switch over to fuel oil. While staff recognizes the capacity and system pressure constraints at 1212 Winterson Road and concludes it would be infeasible to become a Schedule C customer because of this, staff concludes that Northrop Grumman should either contract for OFDS for its critical manufacturing processes or reevaluate the appropriateness of hosting such processes at a facility without firm gas service. Factor 3, efforts to correct non-compliance during the interruption. As previously discussed, the facilities engineering and boiler operator teams at 7323 Aviation Boulevard immediately communicated upon discovery that premature resumption of gas usage had occurred to revert the boilers to fuel oil. Staff recognizes the immediate action upon realization of the communication failure, and staff's engineering division recognizes the complicated operating nature of the fuel oil boilers and the requisite skill sets that are needed to operate them. But staff also concludes that a breakdown in communication, as described, is a substantial failure on the part of an interruptible customer. Staff, again, strongly urges Northrop Grumman to add significant redundancy to its communication protocols for interruption events. With regard to 1212 Winterson Road, again, this property was successful in its ability to curtail 91% of their normal or typical usage, with only the previously discussed natural gas exclusive manufacturing processes consuming gas. And finally, factor 4, customer actions after the interruption to be fully compliant in the future. With regard to 7323 Aviation Boulevard, staff asked Northrop Grumman in its data requests about its efforts to improve its communications protocols to mitigate against future potential similar situations. Northrop Grumman explained that it has been actively coordinating with BGE to, quote, update appropriate distribution lists with additional points of contact to ensure proper communication flow for interruption events in the future, end quote. With regard to 1212 Winterson Road, Northrop Grumman explained in its data request responses that it was going to contract for OFDS at the property, specifically for the critical manufacturing processes that rely on natural gas. While staff appreciates Northrop Grumman's corrective actions for both properties, staff concludes that it is the responsibility of an interruptible customer to ensure that they understand all terms, conditions, and requirements of the tariff under which they receive service. This includes understanding the ability to contract for OFDS, and it includes ensuring that proper communication protocols are in place such that relevant parties involved in succeeding in curtailment are notified of all pertinent information affecting their ability to do so. Staff requested the February 2025 to February 2026 gas usage data for each property from BGE in a separate data request in order to estimate the savings that Northrop Grumman has received as a Schedule IS customer compared to if they were a Schedule C customer. Staff's estimation calculations are discussed in the buck sheet and provided in detail in Attachment 3. Staff acknowledges that Schedule C is presently unavailable for 1212 Winterson Road as discussed, and presents estimated savings for that property strictly for informative purposes only. Staff estimates that Northrop Grumman has saved approximately $737,908.04, or 53.4%, at 7323 Aviation Boulevard. Staff estimates that if Schedule C were available at 1212 Winterson Road, this would result in approximately $240,774.31, or 56.7% savings. Combined, these savings are approximately $978,682.34, or 54.2%. Staff has evaluated Northrop Grumman's request and data request responses and has concluded that there were substantial failures in its communications protocols and in understanding the OFDS terms and conditions of Schedule IS. With regard to 7323 Aviation Boulevard, staff does find Northrop Grumman's proactive coordination with its fuel oil supplier to ensure timely delivery of fuel throughout the interruption as partial compliance with Factor 1, but finds the communication protocol as described and in place at the time of the interruption to be deficient. Staff does not find the communication failure which led to the premature resumption of gas indicative of any good faith effort under Factor 2. Staff finds the quick action of the boiler operators to revert the boilers to fuel oil demonstrate a partial good faith effort, as they were only made aware of the extension after the primary and secondary contacts informed them as such. This demonstrates partial compliance with Factor 3. And while staff finds Northrop Grumman's efforts to correct its communication protocols appropriate, staff also concludes that these corrections should have been the policy all along. Therefore, staff cannot conclude that a good faith effort was taken under Factor 4. With regard to the 1212 Winterson Road property, while staff recognizes the proactive scheduling of fuel oil deliveries, the consumption of gas was constant throughout the event at approximately 9% of average daily usage. This could have potentially been entirely avoided if they had understood the OFDS terms and conditions of their tariff. As they did admit that they did not know that that was an option. Therefore, staff does not find there were any good faith efforts demonstrated under Factors 2, 3, or 4. Staff acknowledges that Northrop Grumman has agreed to contract for OFDS in the future, but finds this to be a corrective action in response to a better understanding of a tariff schedule that they should have initially understood. Therefore, staff ultimately recommends a 25% reduction in the penalty at the 7323 Aviation Boulevard property, and in consideration of the partial satisfaction of factors 1 and 3 from 34,791.22 to 26,093.42, and recommends a 10% reduction in the penalty at 1212 Winterson Road from 113,071.45 to 101,764.31 in consideration of very partial good faith efforts under Factor 1 to proactively schedule fuel oil delivery. Staff also recognizes that the consumption of gas at 1212 Winterson Road was limited to approximately 9% of average daily usage. With that, I thank you very much, and I'm available for questions.
Good presentation. Questions? Commissioner Suchman.
Well, first, thank you for a very thorough presentation. I had to actually go through it a couple of times because there's a lot of moving parts in this. So for the first property, they ended up being 99% compliant. Is that
No, that's for the second property.
that was for the second
Yeah.
property?
And it was 91%.
I thought the second property was 91%.
Yes, sorry, I was just clarifying that the second property was 91% compliant. Yeah.
Right. I'm talking about 7323.
Oh, specifically, sorry, I misunderstood.
Yeah.
Yes, you're correct. It
Okay,
was only
so
3 hours.
Right, and so, and in neither situation, for neither of the properties, was there a failure of alternative systems, which we've seen in other requests for reduction of penalties. That there was a failure in the system. That was not the case here.
That's correct. There
Okay.
were no mechanical failures.
Right. So for the first property, there was a failure of communication.
Yes.
And some of the problem was WGL in miscommunicating the line, but in the body of the email was an alternative request, and they said they contacted WGL, but they didn't get clarity on that.
You are correct. There was a discrepancy in the communication from WGL Energy. Based on their responses to our data requests, they said they contacted BGE to confirm that the interruption was even happening, but they admitted they did not contact WGL to confirm the discrepancy.
Okay, so that was a problem.
Yes.
And then the second problem was that the two people who were notified were unavailable. Well, the first one was unavailable, and the second one didn't do anything.
Yeah, the second one had just assumed that BGE sent it to everybody, which would include the boiler operators, but as it turned out, based on what we've seen, only the primary and secondary were contacted about the extension.
Okay, and then did Northrop Grumman share with you ways in which they will make sure that this doesn't happen in the future?
We had asked them in our data requests throughout the discovery process, what is your communication protocol? Are you going to improve it going forward? And they responded that they were actively working with BGE to update the contact lists, but they didn't go into much more detail than that.
Okay, you'd think that they'd actually provide sort of, additional information on how they can make sure that this doesn't happen again. Because the point of having interruption is that this assures the gas system that they can provide gas to the people who need it, who are on firm service.
Correct, yes.
Right. Okay. I'm more concerned about the 1212 Winterson Road property because it seems to me, is it your sense that when they initially went to BGE and asked for firm service, they were told that there was no firm service available?
Based on their responses to data requests, that's how we understand.
Okay, so it wasn't that they wanted interruptible service, it's that they knew that they couldn't get firm service. And yet they knew that there were processes within their system that required firm service. And that's very troubling because that's kind of going in with eyes wide open and knowing that if there was an interruption, they would continue firm service for service that was not firm.
That's correct. Staff
Yeah,
is-
and that's really troubling.
I would agree.
And but they have since been notified that there is firm service available. Do you know why that? I mean, were there additional pipes that were placed in service? Do you know why firm service is now available and wasn't available before?
I do not. All I know is that in terms of firm service, we were strictly talking about if they had the ability to be a Schedule C customer. I would like to defer to BGE for technical discussion of the capabilities of their system. The way I'm understanding the data request responses and the conversation that we had is that the system would not be able to meet its needs on Schedule C, but it may be able to meet a fraction of those needs to serve the critical processes. Because they're taking gas delivery service there now, and they were able to do that during the event. It was non-compliant, I agree. But yes, I think there is a limited amount of capacity and pressure that could meet that requirement at the 1212
Okay,
Wilkerson
and
Road.
can they parse their requirements and say, we'll be on firm service for some aspect of our needs and interruptible on others? It's not an all or nothing.
That's correct, Commissioner. It's not an all or nothing. You can contract for a certain volume.
Okay, and they're planning on enrolling.
Based on their responses, yes, that's what they said.
Okay, all right, that's all I have, thank you.
Commissioner Hoover.
So, as Commissioner Sushman mentioned, this one's a little different than the ones we've considered before, which is, they send out the notice and they switch to the alternative service and then something breaks and they wind up going back to gas. So I guess what I'm trying to understand, and maybe I need to ask some other folks about this, but BG&E sends out the notice saying we're going to interrupt service starting at this date and time and ending at this date and time. Is it routine that they would have a situation, because I assume these are all weather-driven decisions that they make. They do this because, the weather's such a shape that they need to hold off on service to certain customers. But since the weather is sort of a variable situation, is it routine that they have situations where they say, well, the interruption time is going to start on this date at this time and end at this date at this time, and then wind up having to change it because of things in the weather?
I think that that's possible to happen. I would not say that that is routine. I think that the Winter Storm Fern situation was an extraordinary circumstance. We had record low temperatures, extended periods of those temperatures, and that was the first time I had ever seen BGE issue an extension to an already anticipated curtailment event. But admittedly, I've been in the role at a very short time.
I understand that. So
yeah.
And I guess the mechanics of them, when they became aware of the fact that the interruption had been extended, I think you said that they promptly switched back. I mean, how complicated a process is it to, once you've resumed gas service, to go back to using the other thing?
That's probably a question better suited for staff
company.
engineering division. Did you want to? I don't know if you can comment.
Good morning, Commissioners, and again, negotiators for staff. I am feeling Barbara Weber. She asked to be excused because she had to go to Oklahoma City for training. I don't have much study about to answer or to provide to answer to your question how really the setup works for this specific equipment. But through my discussion, my colleague, she told me she didn't find any failure in equipment. But at this time, I cannot provide you how really the switch works from one system to the other.
Okay. And so regarding this property that is on interruptible service because they couldn't get firm service, how long have they been a customer? Do you know?
I do not know that how long they've been an interruptible service customer. I'd ultimately have to defer to the company for that.
All right, so maybe I'll save some of my questions for the company. So that's it.
Any further questions for staff? Okay, thank you very much. We'll turn to the company. Tell us who you are and.
Good morning, Chairman Barvey and Commissioners. Bobby James on behalf of Northrop Grumman.
I have some prepared remarks, and then I have several staff from the facilities, engineering, and operations from Northrop Grumman here to answer any questions that you may have. Given all we've listened to this morning, I'm going to keep my remarks very simple. Northrop Grumman appreciates staff's thorough review of the events involving the BG&E service interruption this past January. We do believe, however, that the Commission should set aside staff's recommendation and grant a full waiver of the penalties, or at a minimum, substantially reduce them for both facilities. Starting with the Aviation Boulevard facility, as you heard from staff, Northrop Grumman prepared under good faith to curtail its gas usage. And it did curtail its gas usage for 165 out of 168 hours. In other words, the facility used gas for only 3 hours, and that happened because of, some would say, a miscommunications, others might say a breakdown in the notification process that BG&E uses. In any event, that's less than 2% of the entire interruption event. Now, it may be true that a customer is responsible for knowing the terms of an interruption event, but part of the problem here is BGE's notification system, which depends on an email reaching the right person at the right time. A simple follow-up call, perhaps, could have confirmed the message was received and avoided this issue altogether. BGE is the expert here. They're the expert in managing interruption services. Because of that, they should perhaps help customers comply and not rely on a system that can feel more like a trap than a fair process. Staff also has suggested that Northrop Grumman's corrective actions were not completely in good faith. But staff also acknowledges that once the extension of the interruption was communicated, boiler operators immediately, and he emphasized the word immediately, switched back to the alternative fuel. Now, they could have kept the boilers running because the event was nearly over, but they didn't. They acted right away and reverted to the alternative fuel. If that's not good faith, I don't know what is. And looking ahead, Northrop Grumman has already taken steps to prevent this from happening again. The full facilities operations group will now receive BGE notifications, and Ryan Massey, the facility engineering manager and primary BGE contact, will provide BGE with the additional names and contact information. For this facility, Northrop Grumman respectfully requests a full waiver of the penalty, or at most, a penalty that reflects the actual gas usage during the interruption, which would be about 2% of the original $34,000 penalty, or approximately $620. Turning to the Winterston Road facility, staff notes that gas usage was reduced by 91%. And that happened, as you heard, because most of the facility is able to switch to the alternative fuel. As you have also heard, there are two critical processes that cannot switch fuels: the solvent waste scrubber and the deionizing water filter system. Briefly, the solvent waste scrubber removes VOCs from manufacturing emissions, and the deionizing water system is used to rinse the microelectronics Northrop Grumman produces. Neither system can switch fuels, and neither can be shut down because of Northrop Grumman's contractual obligations with the NSA. In hindsight, optional firm delivery service would have been the right fit for those processes, and Northrop Grumman probably should have had that type of contract. But BGE also bears some responsibility here, because it never made Northrop Grumman aware that the option was available. Just as with the Aviation Boulevard facility, BGE is the expert here. BGE controls the service options it offers, and BGE is in the best position to help customers understand those options. It's unfair to fault Northrop Grumman for not using a service it was never told existed. That's on BGE. And finally, taking staff's calculations at face value, I didn't run the math, so I assume that they're correct. Staff found that Northrop Grumman saved $240,000 at this facility by being an interruptible gas customer. Staff also recognized that the facility reduced gas usage by 91%, and on that basis concluded that a penalty equal to 9% of the savings would be appropriate. While we continue to believe a full waiver is warranted because BGE failed to inform Northrop Grumman about the OFDS option, a reduced penalty of 9% of the $240,000 savings, or approximately $21,669, would be a more reasonable under these circumstances. That concludes my remarks, and we are available for any questions.
Questions? Commissioner
All right.
Hoover.
So you heard some of the questions I asked staff that they didn't know the answer to. So I guess the question is, can somebody explain to me the process when you found out that the interruption had been extended? You know, how do you go about switching back to the fuel oil? It's literally not flipping a switch, I'm sure. So
Right. Yes, and good morning.
actually, just tell us who you are first.
Oh, yes.
Yeah.
I'm Jack Leake. I'm the Director of Facility Engineering
Okay.
for Northrop Grumman Mission Systems.
Mhm.
And again, good morning, Chairman and Commissioners. So the process is approximately, it's 2 hours to switch back.
I see. Okay.
And so it was 1 hour before we got the notification over to our operators, and then it was 2 hours to switch.
Okay.
And that was the duration of the 3 hours.
So, as was the discussion I had with staff was that, you know, the normal story that we've had in these situations is, you know, BG&E sends out the notice for the interruption, the company starts doing that, the equipment breaks, and they wind up having to go back. Yours is different just because of this issue of the interruption being extended. Now, when you came onto this service, I mean, did BG&E explain to you that, you know, while you may get a notice that says the interruption will start at this date and time and end at this date and time, since these situations are driven by weather events, which are variable and unpredictable, did they tell you that, look, there is a chance that on certain situations the end date could be extended?
So that was not communicated to us,
Okay.
and we have not experienced in the past an extension beyond their initial timeframes.
Okay. And the system that's on interruptible service, because you couldn't get firm service, how long has that situation existed, if you know?
6 months. That was a new tool that we had installed
I see. Okay.
to
So,
support.
so this is actually the first time that you had an interruption event that you had to deal with, because I'm assuming that, you know, for your other facility, you've gone through this before and kind of know the drill and things like that. So.
That's correct.
Okay. All right. That's it.
Any other questions? Suchman?
Good morning. Oh, we're almost at afternoon.
No.
Having fun?
Yeah.
Don't you like being the last person watching? Yes. Okay.
I think it's better than we expected. We weren't sure how long. It
Oh,
was
good. I'm glad you're having fun. That's our goal. Okay, so talking about the Winterson Road property. So that property has been in place for how long?
1961.
Okay, a long time. And so you just went on, I guess I'm a little confused in your response to Commissioner Hoover. You've been an interruptible customer there for how long?
So we have an uninterruptible service just to support our kitchen equipment. And that service couldn't be upsized to support this new equipment that we put in. And we actually tied the new equipment into the uninterruptible service, and it wouldn't function. So that's when we had to go over to the interruptible, and then we were unaware of the optional firm delivery service that BG&E offers.
Okay, so so you do, at this facility, you have both interruptible and firm service.
Correct.
Okay, and then these new these new processes, they're new. They were just put in place.
Correct.
And you didn't know that you could tie them into, or you had assumed you could tie them into your firm service,
Correct.
but you couldn't.
We did, and it wouldn't supply the pressure or the flow to support the new equipment.
Okay, and so and you discovered that when?
After, that would have been roughly, so for one of the tools, it was 6 months ago,
Okay.
and for the previous tool, it would have been over a year ago.
Okay, so this is actually relatively new. Did staff know that because in reading their buck sheet, I didn't have an understanding that the processes actually were relatively new processes, and I had assumed that they were processes that you had that had existed and that you knew needed firm service, and you just took advantage of but that was not the case.
That's absolutely not the case.
Okay, that's incredibly helpful. Okay, thank you.
Yep.
Any further questions for the company and its representatives? Quick one?
Just to respond to Commissioner Suchman, no, we were not made aware of that at any point during this. I'm just now learning that this was a recent decision. That's all.
Make it quick.
And if you had been aware of it, would that have changed your recommendation in terms of the reduction of the penalty from 10%?
To be honest, probably not. Again, the tariff is very clear and what the requirements are. I understand being new and understanding, you're learning the new terms and conditions in application versus just reading them. But again, it is the responsibility of the customer to understand the terms and conditions of the tariff, which means contracting for OFDS. If this was a known process and they tried to put it on firm service and it wasn't working, before going on a new tariff, I would expect that the customer would fully understand the terms and conditions. To be totally honest with you, Commissioner, no, that would not change my recommendation.
Okay, thank you.
Any further questions before we proceed to a vote? Okay, we'll proceed to a vote. Just to recap, the motions are to grant a reduction of the distribution interruption penalty for 7323 Aviation Boulevard by 25% to $26,093.42, and to grant a reduction of the distribution interruption penalty for the 1212 Winterson Road property by 10% to $101,764.31. Commissioner McLean.
Actually, before you take the vote, I'm
Okay.
just going to offer an amendment.
You are okay.
So I would offer the amendment that we change the percentage from 25% to 50%, and the second one from 10% to 30%.
Okay, so we would change, let me just write this down so I'm clear about this. The first one would be changed from 25% to 50?
Right.
Okay. And the second would be changed from 10% to
30.
what?
30%.
30. Any discussion on that amongst the members of the commission?
So if I can just, and we've actually had these kinds of conversations with other parties as well. And I actually agree with Commissioner Hoover that that hearing from the company today has made me feel better about offering an additional reduction penalty.
Okay. On the motion for the amendment, all those in favor signify by saying aye. Opposed,
Aye.
no. The ayes seem to have it. The ayes have it. Let me reread then the motion, and it is to grant a reduction of the distribution interruption penalty for the 7323 Aviation Boulevard property by 50% to whatever that would be. And I'm an accountant, but I can't do that kind of math in my head. And the second would be to grant a reduction of the distribution interruption penalty for the 1212 Winterson Road property by 30%. Commissioner McLean.
Aye.
Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Hoover.
Aye.
Chairman votes aye, and that the amended orders carry unanimously, and